Asian School of Cyber Laws, and I'd love to welcome all of you to this very special session. It's about a case which has really got me very excited, and I would love to discuss it with all of you. This is the case of India's first conviction under the section on cyber terrorism. It's an old case, but I would love to hear all your opinions on it, have a nice, exciting discussion about it. And what I'm also going to do is I'm going to start by narrating just a story about this entire case. Now, for all of you who are just joining us, please do let me know in your comments if you can hear me clearly and you're able to see me also. And let's then take this ahead. I also have a surprise and a very special guest who's going to be joining me in just a few minutes. Uh, let's start with the story of this case on cyber terrorism. Our case begins on 18th of October 2014, which is almost 9 years old, when Pramod Pawar, who was a member of the anti-terrorism squad in Mumbai, received intelligence about a possible attack on a school in the city. The intelligence concerned a gentleman by the name of Anish Ansari, who was an Associate Geographic Technician. To be very honest, I haven't understood what this position was at a company in Mumbai city by the name of Here Solutions Private Limited. Uh, the accused, Mr. Ansari, what he did was basically he used his work computer and created a Facebook account under a false name. This account was then opened on his work computer itself, and using the account, he contacted somebody by the name of Omar El Haj. He discussed how it would be possible to commit a bombing attack on the American school at BKC Mumbai. On the same computer, he also made certain searches, including ones on how to make a thermite bomb. He shared this information with Omar El Haj, and they also had prolific discussions on, their pro ISIS opinions. Both of them had similar opinions, and they had these detailed discussions. All of this happened using uh, Anis's work computer. So now let's take this case forward. Let's see what all we can bring forth, and let's have you apply your minds about this judgment. Also, let's give a quick welcome to Gokul Narayan. Gokul, can you come on now?
Hi, Shuchi.
Hi, Gokul. Gokul is the Chief Operations Officer and my lead faculty at Asian School of Cyber Laws. Gokul is going to be joining us. He's also, he's been in the legal field for over what, 50, 20 years? 50 years.
15 years, yeah.
Years.
More than 15 years.
Yes. So we are going to have him use his own legal head in this also. So let's very quickly. Arshia has told me I'm visible and audible. Thank you so much. Arshia, would you say, I mean, could you also let Gokul know if he's visible and audible? Is that also possible? Can someone just quickly put in a yes in their comments? Well, let's hope for it. Gokul, we are hoping you're visible. Okay,
Yeah.
anyways, coming back. So, very quickly, let me ask a very quick quiz question. You guys heard the story. Okay, he used his work computer. He was a technician, and he basically had technological knowledge. He created a false Facebook account. He used that work computer to plan some kind of a bombing attack. He also conducted searches on how to make a thermite bomb. Now, I want to know, yes, I know that this is a cyber terrorism case, but have any crimes been committed, and which are the crimes which are committed? Can you put your answers in the comments? Can we have the case number through which we can download the judgment? Absolutely. In fact, what I can do, Pragadish, is that I can actually later on share the judgment with you. Would that be all right?
Shuchi, I'll just put the link in the
Yeah,
this
you
thing.
can do that. You can do that. Can we add a document or something? Is that possible, do you think?
Let me just check.
I mean, I can share it on the screen, but I don't particularly want to. Does that make sense? So, Are you able to do that?
I'm just looking for the judgment online, and I'll just post the link.
Sure, you'll have to look up the Mumbai Sessions Court. Okay, so guys, this was a case which happened on the Mumbai Sessions Court. Now, what I would want to do is, Pragadish, yes, definitely, like I said, we'll try and share the judgment also with you. To be very honest, I am not a lawyer, and I found the judgment fascinating. I loved how they tried to break down every section. They tried to understand whether a certain crime had been committed or not committed. I loved it. So yeah, I would love to share this judgment also with everyone who's here. Okay, so I'm going to repeat my question. Were any crimes committed? And if yes, put down in the comments which crimes do you think he committed. Try to be as specific as possible. Section 67, obscene material. Okay, that's Shripad. Shripad, we'll get back to you with all the answers. Absolutely. Are there any other comments coming through? Come on, creating a false Facebook account. I mean, a Facebook account with a false name. Is that a crime? Okay, let's move ahead on this. Gokul, would you want to just quickly go through the crimes that were actually, they believed that these crimes were committed and that this is what he was accused of finally.
Correct.
So let's come down to that. Yes?
Correct. So, hi everyone. Shuchi, thank you for having me. And I'm just going to express my opinion based on what I've read of the judgment and possibly what are the grounds on which I think an appeal could be filed. So I'm trying to look at it from the perspective of what has been going on in the judge's mind while delivering this judgment, and what possibly the defense could be looking at. Since this is India's first cyber terrorism case, it's more than likely that the defense will prefer an appeal. Now, under what circumstances and how will they be looking at the sections that have been used, and therefore what is likely to happen? Now, if you look at it under the Information Technology Act, there are two primary sections which have been involved in this case. One is Section 43, Subclause A, which is a civil contravention, under which there has been a conviction which has been given of 25,000 rupees as compensation. And then obviously the conviction under Section 66F, which relates to cyber terrorism. There are obviously provisions under the IPC also, like criminal conspiracy and abetment, which have been used. But the idea of the provisions under the IPC will be a little bit easier to bring into focus. The IT Act becomes a little bit more complicated, and therefore the grounds of appeal, if at all the defense so chooses to do so, would be a little easier for them to justify. So let's look at Section 43A. Section 43A of the Information Technology Act talks about unauthorized access. Now, please remember that unauthorized access, as the section talks about, specifically and only talks about accessing a computer system or computer network without the permission of the owner or person in charge. And it specifically uses the words unauthorized access. All right. Number one, the IT Act itself distinguishes between attempt to access, unauthorized access, and exceeding the scope of authorized access. So there are three things relating to access that the IT Act tries to bifurcate in. One, attempting to access. This is most specifically given and most specifically explained under Section 70, which talks about protected systems. Section 43A specifically talks about unauthorized access, and Section 66F, which we will be discussing also, mentions the idea of exceeding the scope of authorized access. So my thinking is, if I were the defense lawyer, one of the first things that I would talk about is the fact that Section 43 subclause A speaks only about unauthorized access. The individual, Anish Ansari, used the office's computer to carry out whatever acts that he did of communicating with the other gentleman, with Omar, and threatening to bomb, and finding out about termite bombs online and researching. Now, all of these activities very clearly are activities he ought not to have done on his office computer. The question, however, is the provision under Section 43A the correct provision under which he should be, the contravention should be made applicable to him?
Also, Gokul, just one point very quickly. So, Pragati here has mentioned criminalizing the use of another name in the public domain will restrain even writers and poets from using pen names. So, which is a very fair point, I feel. It's a very interesting way to look at it.
Absolutely, absolutely. I think that makes a lot of sense. But if it's a fake profile that has been created of another existing individual, then that's a problem.
And what also, I mean, suppose it's just a profile created under a false name
Under a fictitious
without
name.
the intent being considered. Yeah, a fictitious name.
A fictitious
Without
name.
the intent being considered, you can't possibly criminalize it. Am I right on that?
The creation of a fictitious account is not wrong.
Correct.
What act you intended to do through that fictitious account is what is being brought into question.
Correct.
Yeah. So, but thanks so much, Pragadish, for
Pragadish,
sharing that. That makes a lot of sense. Now, Section 43A specifically talks only about unauthorized access. So, one of the questions that the defense is likely to ask is, since the section talks only about unauthorized access and he accessed the official computer with permission, what he did was, after accessing the computer with the company's permission, he did an act which was not within his scope of activity, and it's exceeding the scope, and therefore Section 43A does not apply. This is a likely line of argument that could be taken if this is appealed against. Please remember, there are two separate appeals that may come up. One would be under the civil provision under Section 43A, wherein if that appeal happens, it's likely to go to the Cyber Appellate Tribunal or the Telecom Settlement Dispute Appellate Authority, because it's handled by the TDSAT. And the second one is the penal provision under Section 66F. So I hope my explanation to why 43A could be challenged is clear and it makes sense.
So here, Gokul, I'm going to raise one more point, and you tell me whether then exceeding access becomes a slightly better within the judgment. I mean, does it make more sense to you? So what also happened was, one of the points that the defense for the accused raised was that when he used his work computer, it was seen by his project leader, and the project leader actually pulled him up for it and said, you should not be using this computer, okay, for this kind of activity. Also, the defense said, one of the points raised was that nowhere in the accused's employment contract did it say that he could not use his work computer for this kind of activity, right?
Correct.
However, like I said, I mean, there was a warning given to him, and he went back, and he was actually asked to take screenshots of the activity that he'd been getting up to and send those screenshots to his superior, all of which he did, and he said he will not do it. And then he went back and did the same activity again. Now,
Correct.
does exceeding access make more sense?
See, exceeding access is so two ways of looking at it. You're absolutely right. One, if it is contractually obligated, if it is there in your contract of employment as to what the scope of your activity will be and what you cannot do on that computer, if it very clearly spells out. Like in this case, it did not spell out. However, the process adopted by the organization first said, we request you not to do any of these activities. And then he acknowledges it and he says, this is what I've done and I shall not do it again. Then it automatically becomes exceeding the scope because he's acknowledged what he's not supposed to do.
Correct.
But the question is, do the civil provisions under the Information Technology Act have the ability to address the contravention of exceeding scope.
Oh,
And the defense is likely to say that it does not have the ability. It has the
correct.
ability to talk only about unauthorized access and not necessarily about exceeding the
Exceeding
scope of
access.
authorized access. Because the words used by the legislature while drafting the Information Technology Act very clearly give us an indication as to what words they specifically wanted to use. If you see, in the penal provisions under the Information Technology Act, the words that have been used are attempting to access,
Yeah.
unauthorized access, and exceeding the scope of authorized access under various sections.
Okay.
However, under the civil provision, it only talks about unauthorized access.
Oh, okay.
So it's very necessary that we appreciate that distinction that the legislation has made.
Okay.
And that I believe that would be one of the points of challenge that is likely to come up if this goes up in appeal. One. Two, the provision relating to cyber terrorism itself, it's a slightly difficult provision. The manner in which it has been drafted makes it very difficult to interpret it in most situations, which are likely to, under normal circumstances, to resonate with individuals, that cyber terrorism would be applicable in this case. The manner in which the section has been drafted itself makes its application a little complicated. Now, if you look at the provision under under the cyber terrorism thing, section 66F, there are three parts. So the cyber terrorism provision has been divided into two larger parts, which talk about act done by an individual, one, and secondly, about the impact that that act has. Now, over here, the relevant provision, is there an ability to share screen, Shuchi, by any chance?
Yes, of course I can.
Can I send you a link, and can you share that then?
Are you looking at section 66F?
Yeah.
Let me try doing it, okay?
Can I send it to you by chat?
I'm apologizing right up front. This is the first time I'm going to be actually trying to. Yeah, I've got this. You sent me the link earlier
Okay.
for section 66F. Let me just try doing this. Just one moment. Let me see if I can share.
And I'm requesting everyone, we're just having a discussion on this. If any of you have any questions about it, just feel free to drop in your queries immediately. Don't think too much about it, and we'll ask later and things like that. Just put down your questions. We may, in the course of the discussion, automatically address those questions. But in case we don't, let's hope that you don't forget it. So please ask your questions as soon as it crops up in your mind.
And also, I'm going to keep trying my level best to put up comments as much as is possible. You just saw Pragadish's comment also. As and when you guys put up comments, we will try and put them up on the screen so that everyone can see what is being discussed. And before we move to 66F, Gokul, I am going to. So this is one of the questions that the judge asked himself before coming to a judgment. Did Anish contact Omar El-Hajj and discuss ideologies of ISIS? Did he post offensive messages and extensively plot a conspiracy to launch a lone wolf bomb attack on the American school at BKC, Mumbai, with the intention of causing, the death of the children there, and of course destruction of property, and with the malified intentions of causing terror, threatening the unity and integrity and security sovereignty of India? These are some of the, so with the intention of completing this mission, did he get information about creating a bomb? These are the questions that the judge raised. And he also tried to ask, so the net, this thing was, should he be punished under section 66F of the Information Technology Act? Now, what I'm going to do is I'm going to share a screen of mine. Okay, Pragatish has said any provisions of the UAPA Act involved. That's one. And Neha has said, hello, sir, I've joined a bit late. Can you please brief which case we're discussing? Okay. So Neha, all right, very quickly, we're just discussing the Anish Ansari case, which was India's first conviction under cyber terrorism. That is what is going on. I mean, welcome. I realize that you've joined a little bit late, but this is excellent. The wordings in section 66F is to technology neutral to capture the actual intention of the legislature. Example, denial of access to authorized personnel actually refers to DOS attacks, but the wordings can be easily misread. You're absolutely right. I'm showing this This is Advocate Dr. Kuruvela Matthew. Okay, so you can read the comment also. Let's hide this and let us share screen, guys. I'm just going to try to share my screen with you. Let's see. Is everyone able to see my screen, which says Section 66F, punishment for cyber terrorism?
Yes, I can see it, so I'm presuming the rest of them will also be able to see it.
Okay, okay. Do I need to make the wordings any larger or something? I mean, people can just put in their comments and I can always help, I think.
Yeah, unfortunately, there's a screen on my left because of which I'm not able to see it. All right, I'll just open it on now. So let's have a look at this section 66F. It's if you can see, it's divided into two parts: subclause A and subclause B, capital A and capital B. Let's look at capital A. With the intent to threaten the unity, integrity, security, or sovereignty of India, or to strike terror in the people or any section of the people. So, Section A, Section 66F, capital A, seems to be very clearly applicable over here because there was intention to threaten the integrity, strike terror in the people with his act. With the intention was basically to do something like that. So that's not a problem. 66F, capital A, this part till now seems to be something that has been satisfied. But however, it requires one of the following three to be done in furtherance of this intention to threaten the unity and integrity. And I say one of the following three mentioned under Roman 1, Roman 2, and Roman 3, because if you see after 1, there is an or, then there is after 2, there's a semicolon and an or. So it's either 1 or 2 or 3. So let's look at 1. Denying or causing denial of access to any authorized person to access a computer resource. This hasn't happened because there was no denial of access. There's no authorized person who was denied any access. That's not a problem. Now, second one, and this is where I believe the judgment has, the part that the judgment has tried to rely on to convict Anish Ansari under 66F, attempting to penetrate or access a computer without authorization or exceeding authorized access. Now, although the words exceeding authorized access are used over here, we need to understand that in this section, the intention is to talk about attempting to penetrate or access a computer. So, attempting to penetrate or access a computer exceeding the scope of authorized access. So, some part that you're not allowed to access, you try to penetrate or access, and that thereby exceeding the scope of authorized access. In any case, we'll discuss that. The second part is that. The third is introducing or causing to be introduced a computer contaminant. That's not happened over here either.
Not at all.
So it seems likely that it's 66FA subclause 2 that has been used.
Yes.
But the section still does not end. There's a third part to it. Then it says, and by means of such conduct causes or is likely to cause death or injuries to persons or damage or damage to or destruction of property or disrupts, knowing that it is likely to cause damage or disruption of supplies or services essential to the life of the community or adversely affect the critical information infrastructure specified under Section 70. So the last part is not relevant, where it talks about adversely affect the critical information infrastructure specified under Section 70. Which is the part that is relevant over here? And by means of such conduct is likely to cause death or injuries to persons or damage or destruction to property. Now, let's try and break this down. So clearly it's 66F capital A subclause 2 and the last part that he's likely to cause death or injury. If you look at subclause B, again, that's not applicable very quickly because subclause B talks about knowingly or intentionally penetrates or accesses a computer resource without authorization or exceeding the scope of authorized access, and by means of such conduct obtains access to information, data, computer database that is restricted by reasons of security of the state and foreign relationships, blah, blah, blah. So very clearly, that part is not applicable because over there, by exceeding the scope of authorized access and entering into a computer or computer resource, this individual has gained access to some information that he was not supposed to have access to. So that's not something that's happened in this case. So it's not relevant to our discussion. According to me, and please feel free to share your opinion. Shuchi, please feel free to disagree. My opinion over here on what the prosecution's likely, the defense is likely to appeal if the appeal is so preferred, would be to state, first of all, that subclause 2 intends to penalize attempting to penetrate or access something that you are not allowed to penetrate or access. All right. So it could be applied in a situation where, let's presume I'm an employee of an organization. I have access to certain files of the organization, but no access to other files in the same organization. They require a higher security clearance, for example. Now, in such a situation, after having gotten authorized access into the system, which I, according to my level of security clearance, am allowed to do, then attempt to access that other part which is restricted to other people, then this would be applicable. In our given scenario, the individual did some act using the computer which he was not supposed to do.
But wouldn't also, I mean, just think about it.
Yeah.
When he continued to use the computer in excess of what he was allowed to do or what he was not allowed to do,
Correct.
wasn't he still accessing a resource? I'm not saying that particular computer resource, but
Correct.
a resource
Correct.
which he was not supposed to, and his intent was still to threaten whatever unity, integrity, security, sovereignty kind of thing. So wouldn't
Absolutely.
that sort of apply?
It could, but
Yeah,
the defense may raise an argument that he was not attempting to penetrate or access a computer resource.
correct.
There was nothing else he was trying to penetrate or access. He already had access and he misused that access. But
The truth.
further to that access, he was not further trying to penetrate or access some other resource which he was not allowed to
No,
access.
no, that's
That's
true.
the likelihood of the line of argument that could be taken. I don't
Correct.
know. I'm just trying to see how we could extrapolate the information that we already have to further discuss this information.
Correct. Now, just 1 second, Gokul. I'm going to stop
Yeah.
you here for 1 second. So, Amartya has asked, don't Indian cyber authorities have any mechanism? Just 1 second. I'm going to put this up on the screen also, that flag the behavior on internet hinting towards these kind of things, like the US has, where the authorities and government are flagged on such kind of things.
I think that's exactly what's happened over here, because of which
Somebody
this
has obviously reported it.
correct
Yeah.
this flagging of such information is possible because there are agencies which are constantly monitoring what kind of conversations, what kind of activity, what kind of searches are happening online,
Yeah.
and through those activities they are able to pinpoint. That's exactly, if you see the first part of the introduction to the case that you
Correct. The
started off with.
ATS got involved because of some information which was given to them.
Correct. Correct.
Yes.
Amartya, I don't know of the nature and the extent of what kind of monitoring facilities that it is that the Indian intelligence agencies possess, and what is the extent of it. But most certainly they do. There's no two ways about it.
Correct.
Monitoring happens. The extent and the effectiveness of that monitoring system, I don't know enough to comment on it, whether it is good, it's bad, it's not good enough, or it's good enough. I don't know enough about it.
Gokul, shall we go ahead on 66F, or would you also like to discuss a little bit more about this?
Yeah, no, just
Yeah.
I just wanted to conclude my 66F line of thought in terms of what the likely argument is supposed to be. If you look at the second part, Shuchi, it says, and by means of such conduct is causes or is likely to cause death or injury. What is it that is likely to cause, or what is it that is likely to cause, or what is it that causes or is likely to cause, sorry, death or injury? The act by which the individual is threatening. But the act over here was only research. The line of argument that could be taken up by the defense is, the act that we are talking about is at best a conversation about bombing a particular place, a particular school, and research on how to make the bomb. That act of researching and having a conversation could not have led to
Cause
death or
death or
likely to
injuries.
cause death. There
Yes.
has to be some act in furtherance of that conversation to lead to death or likely to cause death. And this also could be one of the lines of argument that could be taken up in
If an
case
appeal
an
is
appeal is
filed.
preferred. Yeah, yeah. Does that make sense? Does the
Well, so to be very honest, Gokul, I believe that the courts will take that up, of course. But you're right. There was no act which could possibly cause or was likely to cause death or injuries. But on the other hand, when you take the first part again with the intent to threaten, so when you start to consider intent, and you know so an act may not necessarily have been done, but the intention to do it was there, and they are basically saying that the intention is the same thing as the act. And if they consider it like that, then most likely there is the possibility that it may not really be considered. I mean, this kind of a defense where he has not really done an act per se, which could cause death or injuries.
possibly,
um,
Shuchi, possibly,
yeah,
absolutely right. That the possibility of interpretation is wide open. We can
correct.
only speculate on what direction the courts could take or the prosecution and the defense could take. But it's something that we should wait and watch.
Oh, this is a new one, Gokul. I don't know whether you're able to see Dr. Kuruvala's the thing. I'm putting it up on the screen here. Isn't Section 69 authorization required for a monitoring, especially now that privacy is a fundamental right under Article 21?
Um, isn't Section 69 authorization required for a monitoring, especially? Uh, I I I couldn't understand the question,
I think
Dr.
it is with regard to the monitoring which has been mentioned by
Sec-
Amartya, if I'm not
Yeah.
wrong. Yeah,
Okay.
yeah, it is with regard to that, if I'm not wrong.
Okay.
See, honestly, I'm not entirely sure what the law on this is. Yeah, he says that that is spot on, sir. I could be conducting the research for the next thriller I'm planning to write. So, okay.
Correct.
uh,
Correct. So it could be a line of argument that could be taken.
Yes, that's a possibility. But obviously, someone somewhere did report it because this report was sent to ATS Nagpara, and they are the ones who basically led the investigation.
Correct.
Um, so, Dr. Kuruvilla, that's a possibility that someone may just have been conducting research on the next thriller that they were planning on writing. And well, they got this kind of monitoring led to something really dangerous happening to them. But yeah, yeah, absolutely. Like I said, so Section 66F also seems to be leaving, even if you were to read it word for word, it seems to be leaving a lot of space for doubt and maybe also an appeal which could arise.
Correct. The
Yeah.
possibility is very high. And this has lesser to do with the nature of, according to me, has lesser to do with the nature of the offense that we're talking about over here and more to do with the manner in which the section in itself has been drafted.
Hmm,
There have
hmm.
been numerous cases in which cyber terrorism could have been applied, in my opinion. But
Okay.
the manner in which the section has been drafted itself has made it literally close to impossible to successfully apply. There has to be a reason why, since the section has been brought into force through the 2008 amendment till date, that there have been no convictions, and this happens to be the first one. The reason is it's not that people have not used the internet to spread fear. They have not used the internet to research on activities which is likely to cause this kind of and these kind of investigations have also happened. But the application of the section has not been very successful because of the nature in which the section itself was drafted.
Even hate crimes for that matter. I mean, there are so many of those where you could speak about the integrity, unity, sovereignty of the country being threatened. But at that point of time, this kind of a section was not really applied. Yeah. Okay. So before we move on, so this is another point which was really exciting to me, at least, right? Uh, when you think about the prosecution and the defense of any kind of a case, one always thinks that there would be hugely different points that were raised But this particular case had something very interesting. The prosecution said that this was a youngster who had been arrested in 2014. He had already, given up about 8 years of his life. That is when this judgment came in. He had already given up about 8 years of his life. He was the sole earner of his family. He was technologically qualified and hence could possibly go ahead and actually help his family, settle onto some kind of a lifestyle, right? This was what the defense said. The beauty of it is the prosecution used a similar point. They said this youngster, he's a youngster, he's technologically gifted and has his talents there, which means if you let him off, if you let him go on a leniency plea kind of a thing, well, there is the possibility that he will go out there and he will do this kind of thing again. And so, if you realize the same technological capability of this youngster was used by both the prosecution as well as the defense. So, I found that that was a fascinating way to deal with it. Gokul, are you back?
Yeah,
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 there you go. Huh?
and this is a conundrum that most judges find themselves in. This is what kind of judgment should be delivered, keeping in mind the interest not only of the person who is the perpetrator over here, but also of the public at large, and balancing the rights and interests of everyone concerned is one of the most um, difficult jobs that could possibly be taken up. That's why it's easy for somebody to sit on the sideline and poke holes into a judgment and say, "Oh, this is wrong or that is wrong. This should not have been done. That should not have been done." It's an easy task in
Very
retrospect
true.
to sit down and then analyze, because I have time. I have no pressure. I have no requirement of delivering a judgment which will be combed through with a fine tooth. But these judges who sit down and pass these judgments have this very, very big responsibility and burden on them, that individuals like you, me, and the entire public who's joining in for this discussion has the liberty to actually take a fine tooth and go through it. This word has been used in this sentence in this context. Was this right? Is this the context in which it should have been used? What was the intention? And so on and so forth. So kudos to the judge who's written the judgment. There's obviously, in retrospect, certain aspects that could be that could be brought into question.
Yes, and most often, as often as not, that is exactly what an appeal is meant for.
Correct.
Can this point be reconsidered?
Correct.
Sometimes, despite the wisdom of the judge and them applying their mind and all of that, there is always the possibility that there is some sort of human emotion, error, whatever you want to call it, which always can play a part. Oh wow, there's a longish comment. Just let me see if I can read this. Just one moment.
I think you need to paste it onto your chat and read it later. It's a
It
massive
does.
comment.
Yeah, it's a huge comment. Just I'm not even able to copy it for that matter. Something to do with monitoring and privacy and the need for transparency in
And
governmental
the
surveillance
Pegasus
practices.
and the
It is
Pegasus
essential
case.
to carefully consider the boundaries between surveillance and privacy infringement. And um, you're very right. I don't even know whose message this is, because to be very honest,
Amartya.
and is this Amartya's? Okay, okay. So Amartya, very very honestly, super point. But if you realize, while the Information Technology Act, and Gokul, you'll need to correct me on this, does speak about privacy, and of course our Constitution says it too. We don't have anything specific as an act on data privacy today, do we?
Correct.
We don't,
Correct.
right?
We don't.
Correct.
We have the IT. There's certain provisions of the IT Act and bills pending, but nothing in force which talks specifically about data privacy. Yes.
Oh, and Dr. Matthew now says ignorance of the investigation division many times causes these sections to either not be attracted or attracted incorrectly. For example, he feels that section 66C and D could be attracted in a number of cases, but the charge is usually on 467, 468. Is that IPC, Dr. Kuruvilla?
Yes.
Yes, correct?
Yeah. Yeah.
Yeah.
67, 66C and D also, Dr. Kirwa, that's a very good point. But section 66C and D are also slightly sections which have been slightly worded in a slightly cryptic manner. But yes, they would be more applicable in these situations than 467, 468. You're absolutely right.
So I'm actually looking forward to whether, uh, as and when it comes in, I hope that the Digital India Act does it clarify these sections to a larger extent. I'm actually
Yeah.
looking forward to that kind of thing, and I'm very excited about it also. Uh, all right, so that's one more part of it. Shall we move on to the judgment also? Should I do that? Is that
Yeah, yeah, please go ahead. Please
yeah?
go ahead.
Okay, so I'm just going to quickly stop sharing this. I hope we are now visible and Gokul is not.
You're visible. You're visible. I just thought I'll
Oh,
just
you
step back.
you did. Oh, okay, okay. For a second I said, did I like chuck him out of the class? What did I do?
No,
Okay,
no,
so
no.
very quickly, the judgment basically said that accused Anish Ansari was to pay damages or fine of rupees 25,000, or to go through a custodial sentence or a simple imprisonment for 3 months for Section 43A, for going against Section 43A. 66F, he was sentenced to suffer life imprisonment, which, by the way, was also India's first life imprisonment under the cyber terrorism section under the Information Technology Act. Now, because he had shared information about the thermite bomb and his plans for bombing the American school in BKC, the section on criminal conspiracy, Gokul, correct me if I'm wrong, 120B, is that right? Okay, anyways, like I said, the section on criminal conspiracy was also used against him, and he was given rigorous imprisonment for 5 years, and to pay a fine if in default, and to have a custodial sentence of simple imprisonment for 3 months. Now, the judge, okay, just 1 second. I'm going to stop here.
No,
Pragadish
continue.
says
I'll
section
deal with
60.
the chats. Continue, Shuchi.
Wonderful, wonderful,
120A is criminal conspiracy, but it's under
wonderful.
section 120. But yes, correct.
Okay, okay, okay. So it mentions 120B, which to be
That's
very
the
honest, I'm going
punishment.
to have to read up on. Yeah,
Fair enough.
but don't worry about it. So now my question is, also, if you look at it, the judge said that all sentences would run concurrently. Now this is something that I would also want to clear here. Uh, yeah, 120B IPC Neha says that. Okay, yeah. Uh, the judge basically gave a judgment that all these sentences would run concurrently and not consecutively, which basically means all of these, I mean, would run at the same time, right? So that again was something that was part of the judgment. What I would like to honestly do is share the judgment with you guys. You can always apply your own mind. We meant this class to be like a discussion, and where somewhere you also start to think like either the prosecutor or the defense lawyer, and you start to think about how would you have dealt with a case like this. This is how, I mean, I feel that you know law becomes exciting even to laypersons like me, because when we realize the intricacy of the sections which are involved, it becomes exciting and it becomes difficult to interpret. uh, Pragadish, could you also tell me what UAPA is? Gokul, you may be aware, I'm not really particularly knowledgeable about UAPA. This is okay. So Amartya says, and I'm going to show this again. Let's just see this. Can you guys see it? Surveillance technologies often lack transparency, creating uncertainty for citizens and even law students regarding the functioning of regulatory bodies. The involvement of various stakeholders, particularly political ones, may also who may be impacted by effective. Oh my God! Okay, this is a longish one. Okay, I'll try and post this later if I can,
Shuchi,
because
UAPA is the Unlawful Activities Prevention Act, but no, nothing under UAPA was spoken about.
used here at
Yeah,
all.
yeah.
That's right. So, Pragadish, that's an answer to your question. UAPA was not used here at all. Only the Information Technology Act and the IPC. Those were the sections that were basically used for this particular case. Okay, yeah, thanks, Pragadish. Okay, so if there are no other questions, do you guys have questions? Do you have points that you would want to discuss with us? If there's nothing,
Amartya,
huh,
you're absolutely right. Amartya in his comment says this opacity surrounding surveillance mechanisms raises concerns about accountability and the potential for misuse. Now,
correct,
Amartya, this is an age-old debate. This is something that has just been exacerbated by the digital world. But that question of governments and how governments maintain control over conversations that its citizenry is having is something that they've since the time of the first attempts made in the Roman Senate to control the voice of the public has been going on. That's a debate that has been going on. How does the government maintain more control, and therefore, in order to maintain more control, what kind of surveillance needs to be done? Now, this activities post the uh, September 11 attacks in America gained a lot of impetus, and
correct.
ever since this debate has been going on, the all governments will turn around and say that to maintain security, to protect the citizens, we need to do surveillance. And the counter argument to that will always exist, that if the government intrudes into every aspect of every conversation that every individual has, it is likely to become a dictatorial state where there is no freedom of expression, there is no freedom of conversation, there is no privacy, and the death of privacy. So the internet was supposed to be that last bastion of free speech, where you could express yourself without fear, without that doesn't exist in that context anymore. And therefore, your comment is absolutely spot on. It's an age-old debate. The question only arises: which side of that fence do you sit on? Uh,
Correct.
if you are a ruling party government, irrespective, and I'm not saying which political party being in power, irrespective, every party would want to maintain a certain extent of control over information that is being
Sent out to the citizenry. Absolutely right, Gokul. Yeah. And information which then gets gathered also, information about what they search for, what kind of, I mean, activities online and all of that. That is bound to happen. Do you think an independent body like judiciary can be better for regulating internet or monitoring instead of executive or state mechanism?
Absolutely not. That's not the job of the judiciary, according to me, at all, Amartya. That has to be something that the executive itself has to take charge of. The judiciary cannot be involved in it. It would be a very major overreach of its
Pause. Yeah.
powers.
Yeah.
It should restrict, in my humble opinion, to interpreting the law and interpreting facts which are presented before it in the context of law. And
Plus,
that's
yeah, plus I think monitoring would actually genuinely um, breach impartiality to a large extent if they were
correct,
in charge of monitoring. So I
correct,
think the
correct.
judiciary can't afford to get involved with,
Absolutely.
monitoring powers.
Yeah.
So,
But thank
anyways,
you so much, Shuchi, for
yeah.
having me over here. You can bring the discussion to an end if you so like. But thank you so much for having me,
I'm
Shuchi. I
about to do
had
that.
a
I'm about
fabulous.
to do that. Gokul, it was a lot of fun.
Yeah.
Guys, what we want to do is to also have discussions like these on other exciting cases. And we're going to keep bringing this kind of a session to you. We'd love to have hear from you how you react to it and how you enjoyed it. Please do put that in the comments. And you can, I mean, you guys are either on YouTube or on LinkedIn. You can always follow us there for more such content. Gokul, thanks for joining me. This has been a lot of fun. Yeah.
And thank you so much. Thank you so much, everyone, for coming in and sparing your time. If at any point of time you want to leave us a comment on what kind of discussions we should have, we should please post
Oh,
that
yeah.
in. Also, we have, thankfully, by the grace of God, being a part of this fraternity for quite a long time, we can bring in a lot of experts to have conversations like this. It need not necessarily be restricted to only Shuchi and me. We can have a lot of people coming in. Let us know what you want us to discuss. What would you want to hear about? And either Shuchi, me, or any of the people that have so gracefully been a part of our journey at ASCL will be very happy to come and have these discussions with you. So thank you so much for sparing the time. Thank you so much, Shuchi, for hosting this and for having me on.
Absolutely. Bye. See
Bye.
you. Thank you,
Bye. Thank
guys.
you.
Bye.